All rise for the pledge.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Clerk, please call the roll.
Councilman Alvarez.
Here.
Councilman Cullen.
Here.
Councilwoman Eckhart. Here. Councilwoman Hudak. Here. Supervisor Hay.
Here. Notations of the exits in the rear and, I think the front and the rear. Any electronic device, please put it on vibrate. I make a motion to come out of the executive session, no action was taken.
I'll second.
All in favor?
Aye.
Work session. First item for discussion tonight is ISW, which stands for Independent Sewer Works, Highlands Shopping Center. We're going to set up some ground rules, maybe. There's not as many people as I thought would be in attendance this evening. I do want to ask a question. How many attorneys do we have in the room? Wow.
Wow.
We're outnumbered tonight, big time. Now, the reason I ask that question, gentlemen, you're representing someone, and I see a lot of the actual tenants of the shopping center not here this evening, so you're there representing their interests. Now, if there was about 50 people in the audience, I'd limit your time. So at this point in time, to the main two, we're going to say 15 minutes and 10 to the other. And one thing I'd like from all the gentlemen, especially the attorneys, you have given us numerous pieces of documentation for us to read. I hope whatever you're going to present to us is something different, or just highlight what you sent us. I know I read the documents, and it's not fun reading. So in the future, put a couple of jokes in the middle so you can test us to see if we read it. Put some pictures in there. I won't say what kind, but do something that's more interested in reading what we've been reading. We've been reading about a year and a half now, maybe 2 years. So spice it up the next time, please. So, again, when I say that, Rick, your side, I'll say 15. You're representing one side. Mr. Natoli, you represent the other 15. And the other gentleman, if you don't mind, 10 minutes. We've read all your documentation. 2 minutes. Even better. Are you going to say 4?
I'll say 5.
Okay. Okay. Go ahead, gentlemen. Thank you.
Good evening. Richard O'Rourke, on behalf of Independent Sewer Works Corporation. Obviously, we are the petitioners on this. And here tonight with me is Mr. John Guastella, who is our rate consultant. My comments will be very, very brief. John's might be a little bit longer. But what I want to do, if I may, is just briefly set the scene for what this is all about. And it's very, very straightforward. And I think it's important that there's just some key points that have to be kept in mind. One of the things that relates to this whole business of setting the sewer rates, and the New York State Legislature decided that town boards should set sewer rates for these transportation corporations that have to do with sewer. Water rates are set by the PSC. We all know about the PSC, foremost rate-making body in the state of New York. They have staff, they have accountants, they have lawyers. But when it comes to the rate setting, there are a couple things that are very, very important to keep in mind here. One is this sewer plant is and was the first one after the New York City watershed regulations became effective in May of 1997. Those regulations had been last revised in 1953. So after 40 some odd years, after the Korean War, after the Vietnam War, after the Iraq War, all of a sudden, these new regulations came into place, and guess who was the poster child for those regulations? This sewer plant. And what happened was, it was very important that, and have to be respectful of the New York City Department of Environmental Protection, New York State Department of Environmental Conservation, they said, we want a plant that's going to be excellent, that's going to be something that will work and protect the water that is provided to 12 million people. So what happened was, the developer, with all due respect, he didn't want to spend a lot of money. He didn't want to build a huge plant, but nevertheless, the regulatory authorities said, build a plant that is perfect and that provides for what we believe the necessary protections for the watershed. And so, based upon square footage large part of this, based upon square footage, there was a determination made that the plant had to have certain whistles and bells, certain protections, and it was expensive. Related to that, and Mr. Guastella will explain it in greater detail, obviously, there was a water company as well. Those rates were set by the Public Service Commission. It was the Public Service Commission that decided using square footage as an appropriate mechanism for setting the rates for this property. Very unusual, unique in the sense that here we are, first out of the box with these new watershed regulations. Secondly, unusual in the sense that you have a commercial campus, if you will, of 17, 19 customers, different sizes. How do you take care of this? Because most importantly, under the law, this is a separate entity. It's distinct. It's a corporation under New York State law, and that corporation has to survive. It has to provide the services that are necessary. It has to be able to attract capital necessary for its operation. And so that rate setting has to be something that makes sense and allows the companies to remain financially viable. Because if not, then you're going to own this company, and you're going to have to deal with these rates. Otherwise, these separate entities have to do it, whether it's water or it's sewer. PSC looked at it, said, you know what, square footage, given this set of circumstances, works for water, and that's for the sister utility, and that's something that carries over, particularly as it relates to sewer. I've said enough. I'm going to turn it over to Mr. Guastella. He's got a couple points to be made, but I think it's important that you understand what we have here and the importance of having a corporation that can be functional and viable. And I'll leave it at that. Mr. Guastella?
You went over your limit, by the way. Sure. Make a motion to accept the rules, to take the additional?
Second.
All in favor? Aye.
Thank you.
Yeah.
Second. I second.
All in favor? Aye.
All right.
Thank you.
Does Mr. Natoli?
Good evening. Rick said I'd be brief, and I'm going to try to just go through this very quickly, really to cover the main points of the decisions on the rates. The first side heading is ISW's approved rate structure. That's the rate structure that the town board approved initially over the years and then subsequently in your recent decision. Your rate decision was exactly in line with fundamental rate setting principles. It's cost-based, and Rick already advised you that the primary cost of the sewage treatment plant was based on square footage. The rest of the costs are pretty much fixed. There are very little variable costs. The rates must be able to produce the revenue requirement. Very important for a system that only has a handful of commercial customers, where if you base the rates on something that's like water use that can fluctuate, you may not be able to generate the revenues that you need from year to year to keep the rates stable so that the utility can maintain financial viability and continue to operate. The fixed rate for the square footage does that with a small portion based on usage. The small portion based on usage, the reason for that is that there are very few costs of operating this utility that are variable, and I'll get into a little more of that in detail later. They must be fair to the customers, and the customers should expect not to have major changes once the rates were established when they got involved with this commercial development. There is a Public Service Commission of New York, what they call an initial rate policy. One of the provisions, and just to let you know, it was really developed for residential utilities, for water utilities. This is a different situation than the Public Service Commission has faced before when it dealt with Independent Waterworks, the sister company of the sewer company. It's different because the Public Service Commission in New York regulated At the time, maybe some 250, 300. When I was with the Public Service Commission, it was about 400 small water utilities. I helped develop the initial rate policy, left the commission, and about a month later, what we worked on came out as an initial rate policy. One of the provisions was, when somebody buys real estate or leases real estate of any kind, they expect that the rates for utility service would increase relatively in proportion to inflationary increases, without any dramatic changes. In this case, if you switch to a predominantly usage rate structure, the impact on the customers is going to be very dramatic, not anticipated when you first set up the rates. And the rates that you first set up and the rates that the Public Service Commission first set up were primarily based on square footage. I developed those rates, I know, and you developed those rates which are consistent with the fundamental rate-setting principles, but also enables the utility on an ongoing basis to maintain financial viability and not have to deal with the risks of changes in water use, either increases or decreases. The fact of the matter is, if the water consumption, which we don't know whether all the water consumption flows back to the sewer system, and that's not completely or accurately measurable at this point, but if you base rates on water use and the water use tripled, the cost of the system wouldn't change for the most part. Most of the costs of this utility are fixed. The capital costs are fixed and the operating costs are fixed. So whether there's an increase in water use or a decrease in water use, the cost of the utility system is not going to change. You don't want to have the tail wagging the dog where you're going to have more revenues or less revenues when the costs are not changing. So there was a fair allocation of costs that was recognized, that you recognized initially and recently. And the rates are not unduly discriminatory. Rate setting is not an exact science. There's judgment that goes into play. So when you present an allocation to a regulatory agency, and in this case you're the regulatory agency, you then use judgment as to what's rate structure best fits the circumstances of a utility. This utility has unique circumstances. The Public Service Commission's decision for the water utility recognized the unique circumstances. There is no other water utility rate that I know of in New York regulated by the Public Service Commission that's based on square footage. I've been involved in some 2,000 or so water and sewer utility rate filings, either directly or very close to directly. I'm not aware of any rate, water or sewer, that's based on square footage. Because I'm not aware, as the Public Service Commission is not aware, of any utility that was confined to only a small handful of commercial customers under the environmental requirements of this utility. There are no other utilities that match it. It's unique. The Public Service Commission dealt with the uniqueness by establishing a predominantly fixed cost square footage rate structure with a small portion of usage rate. You did the same. You basically did exactly what the regulatory requirements require of a utility rate setting body. You establish rates that are going to be consistent with the fundamental principles and also consistent with the uniqueness of the system that you're looking at. The only precedent you have to match your decision is the New York State Public Service Commission, and you match it pretty much exactly, and correctly, I might add. I then reviewed Home Depot's proposed rate structure, which I outline here. Home Depot proposes a usage-based rate structure, which was rejected by the town in your past decision. It now has presented to you a newly revised rate structure, a large part of which is based on usage rates of water use. It's not consistent with the fundamental rate-setting principles that I just described to you. And it's not consistent with the fundamental rate-setting principles that you used in establishing the rates in 2002 and more recently. Contrary to Home Depot's contention to the otherwise, the original design and construction cost of the system was primarily based on square footage and fixed costs. These costs were pretty much dictated by regulatory requirements, which Rick just explained to you. The subsequent use of the plant by large water users do not change those fixed costs. As I mentioned before, whether they use a lot of water, less water, whether you're going to have the same customer mix now as you're going to have tomorrow, whether each customer is going to use the same amount of domestic water, potable water now, or in a subsequent year, it's all going to fluctuate, but the costs are not going to fluctuate. So you can't have the water rates determining what the revenues are going to be when the usage of the customers are not determining what the costs are going to be. Basically, Home Depot is having you reject the PSC's previous and more recent decisions for the water based on square footage. Those characteristics continue, even though the Public Service Commission, in a subsequent decision to its initial rates, knew what the water consumption was. So when the commission made a second decision regarding the water company, the sister water company's rates, it did not change to a predominantly usage rate structure. It kept to this predominantly square footage rate design, even though it knew what the water use was going to be. So the changes in water use did not change the Public Service Commission's mind as to what type of rate structure is more appropriate for a unique utility with a small customer base that's all commercial customers. Let me just touch on the consultants for Home Depot. They have retained two consultants, Delaware Engineering and Reftelis, the firm Reftelis, to prepare a hypothetical design of the system. So the rate structure they're looking at is not what the cost of the actual design was. They now developed a hypothetical design of the sewer system. That's not what the actual system is. There has never been a rate that I'm aware of in the thousands that I've been involved in where the rates were based on some hypothetical design of a utility. It's always based on the actual design of the utility. In doing that, then they shifted the cost to a predominantly usage rate for this utility, which again is something that for this characteristics of this utility has never been done before. So they're presenting something to you that's never been done before, establishing rates on some hypothetical design of a system. Part of their rate is, a large part of their rate is usage. I think about 47% now would be recovered through usage charges, which they call variable costs. There's only a very minor portion of the cost of this utility that are variable. The fixed costs that are in the Home Depot's this current proposed rate design are based on the capital costs of the business. The rest of the operating costs of the business are considered by Home Depot's consultants as variable costs. But what are those costs? I list them here. The plant cost to operate is based on a contract operation. That contract operating costs do not fluctuate at all regardless of water usage, whether the water usage is higher or lower. Accounting costs don't fluctuate because of water use. Billing costs don't fluctuate because of water use. Administrative costs do not fluctuate because of water use. Office expenses don't fluctuate because of water use. Their rate design takes all of the costs other than capital costs, considers them variable, and they're not variable. Even some of the power costs and sludge removal costs do not fluctuate with water use at all. So there's only a small fraction of costs that are actually variable costs. Home Depot's proposal now, which is less in terms of the combination of fixed costs and variable costs, still assigns nearly half of the recovery of costs which do not fluctuate on the assumption that the costs are variable, and they simply are not. Then Home Depot proposes, incidentally, I might say that their consultant, Delaware Engineering, that designed the Dean's Corner wastewater treatment plant, that's one of their first references. Dean's Corner wastewater utility and water utility have retained me to do their rate work. So I'm going to be doing Dean's Corner rate work that Delaware Engineering listed as one of their clients.
Still going to have a job tomorrow?
I'm sorry?
Still going to have that job tomorrow?
Yes, I am.
Okay.
And I'm afraid to say you're going to be seeing me sooner than you think. Home Depot then also proposes that if the shifting of costs from Home Depot to the other customers because of using a high variable usage rate has an adverse impact on some of the other customers, Home Depot is proposing now that one way of taking care of and mitigating the impact on the other customers is to have somebody else pay for those costs. Either a landlord or the owner of the utility. Never been done before. Like I said, I've been involved in a couple of thousand rate cases. I've taught 8,000 students how to set rates in 23 different states. The students come from just about every state in the country and a few people from out of the country. There has never been a rate study or rate setting lesson that would shift the costs of a customer receiving service to someone else who does not receive the service. Utility rate setting is based on the cost of providing service to the customer who receives the service. So the proposal to possibly go another route and shift some of those costs to somebody else to pay for the cost of the service to the customers, never been done before. I'm not going to get into number 9, which you have in front of you. It's just a discussion that there are other decisions that recognize that a large portion of fixed costs should be set in utility rates. When you set the initial rates and in your last decision, as I started out saying, you based it on rate setting principles that are fundamental. You based it on the only precedent there is, the New York State Public Service Commission's decision in the water utility, which has the exact same circumstances for the exact same type of utility. There is no other precedent. You based the rates correctly on utility rate setting principles. You based it correctly on the only precedent that there was. It's my recommendation to it that you do it correctly again. Thank you.
Mr. Natoli? Just for the record, I'd state your name, and I know it, but tell the public, please.
This will be your organizer, so I can hear got a few things. Okay, my name is Albert Natoli. Call me Al, and I represent Home Depot, as you might remember. You don't need my office address or anything, right?
No.
Okay. The first thing I'd like to say is that Home Depot disagrees with the way the town has taken up this matter on remittal, and we've voiced that concern in our correspondence, and we've also have some objections that go from actually before your last decision, and we are reserving those rights. And of course, we're participating in this part of the decision, hoping that you'll come to a reasoned decision quickly, and if necessary, and hopefully it won't be necessary to be back in court. But if we are, we will go and bring up all the matters that we disagree on, not just the rate design. I just want to spend, I know we're short on time.
You're not short on time. Don't let that be an excuse.
Okay, fine.
Now, Mr. O'Rourke was quite handy, and you have a consultant, so if you want to switch, it's not a problem.
Okay.
Just don't take forever.
Well, actually, I'm not going to take forever, and I'll, okay, so I'll stay in order. So let me just explain why I'm here as the attorney for Home Depot instead of somebody else. And that is because I'm a rate consultant as well as Mr. Guastella. As of this May, I'll have been practicing in public utility regulation for 46 years. I started with the Public Service Commission as an engineer. While I was there, I earned my professional engineering license, but it wasn't long after I got to the Public Service Commission that I realized that my engineering education wasn't enough to discharge my duties that were placed on me at the time. So I went back to school. I went at night and I studied finance, accounting, and economics. After I got my master's, I then continued school. I went back to law school at night while I was still at the Public Service Commission, and I earned my law degree. During this 46 years, I've qualified as an expert on rate design as well as an attorney. And I've represented customers, utilities, towns, and villages just like yourselves. So as I'm saying, I am a qualified expert, just like Mr. Guastella. However, just like Mr. Guastella, in this case, I've decided to take the position as a representative advocate. And you can't be an expert and advise a court like you as an expert and be a representative advocate at the same time. You take one role or the other. So the arguments that are made by Mr. Guastella are arguments. They have to be based, and they have to be based on facts that are outside of what his opinions are. I suggest that that's what you do with my presentations, Home Depot's presentations, and that's what you should do with the presentations by the Independent Sewer Company and Mr. Guastella. If, however, you want to take Mr. Guastella's argument as expert testimony, then you need to afford me the same respect and take my arguments as expert testimony. And I can tell you that I disagree with much of what Mr. Guastella just told you was the way things are done in the regulatory process. But rather than go point for point, I'm going to stay with my notes. And my notes, the next is that in spite of all the studying that I did in this field, I have to agree with your expert rate consultant, Mr. Dax, when he said, rate setting is more common sense than rocket science. You all know that utility rates should be based on the usage of the system. Mr. Guastella said that the rates that were set in 2002 were based on cost. That is simply false. The rates that were set in 2002 were based on square footage and ignored the engineering report's analysis that provided 17% of the revenues should have been collected from the restaurant based on the allocation of 30,000 gallons per day that the plant was built. That never happened. It wasn't brought up. In addition, the other things that we know is that the customer mix today is substantially different. And rates are always set. When the customer group changes substantially, they're always set based on the way, on customer demands as they now are in the system. It is, I shouldn't say always, there is some exceptions, but that's the norm. Now, the town has a problem. If it wasn't for this huge difference in rates and having a large effect on the restaurants in particular, because those are the large users, those are the customers that have essentially changed. Those are the customers that the landlord brought into the system. There were 100 seats expected in the engineering report. There are about 570 seats, I think the number is now, for the restaurants in the shopping center. So the shift is what the problem is. We're not, right now all you're addressing is the rate design. You're not addressing the revenue requirement. And as I mentioned, I have some problems with the total revenue requirement as well. But that problem was not caused by Home Depot. That problem is caused by the landlord and Independent Sewer. They decided that they were going to capitalize 100% of the plant and that they were going to charge a rate of return on a $3 million plant to 19 customers and depreciation on that plant. And since the time that they started charging rates, they've collected for net income, or what was charged for net income by their numbers, plus depreciation, about $4.5 million. So they've collected every dime that they've invested in the plant. And almost nothing has been reinvested. And Mr. Guastella talks about needing to be able to attract capital for reinvestment. There's been essentially no reinvestment in the plant in the 16 years that it's been there. And the tax returns from 2011, which was the last tax returns we were able to see, show essentially that there's no significant retained earnings or cash in the company that could be used for replacement of plant. Typically what happens in a shopping center, and almost every shopping center in this state where there's a packaged sewer plant, the sewer plant is charged as a CAM cost and it's the operation and maintenance that gets passed through. If we were only charging operation and maintenance and some allowance for the replacement of the plant, the rate issues that we see here would be gone. There might be a slight increase for the large use customers, but we're not talking about a 400 or 500% increase that would result. This is the result of the plans that were made by the owner of the shopping center as he implemented the sewer company.
Mr. Toller, can I ask you one question?
Sure.
Are you going to be distributing your statements there this evening to the board, or no?
No, I didn't make copies of the statements. I do have copies of Mr. Smith's from Rathalis.
Okay, well, tomorrow, if you have an opportunity, can you provide us with your document like we had earlier from the other gentleman?
Sure.
If you don't
It'll be a
mind?
pleasure.
Thank
You want me to email them or?
You can email, and we'll distribute them to the board as well.
Fine, my pleasure. I could go through, the history of this there's a couple of things that I need, that I'm gonna bring up in history. You guys have heard the history over and over again, but there was, I felt, on the board, a misconception on the part of the board the last time we were here, which was 2 years ago already. It's over 2 years ago. And that is that Home Depot should have known about this in 2002, and Home Depot is somehow welching on a deal that it made in the past. That's clearly not the case. In 2002, the plant was, the rates were set. The Home Depot never got notice of the water rates. They certainly never got notice of the sewer rates. There isn't even a claim by Independent Sewer that they notified anybody of the rate application on the sewer rates. So no one had an opportunity in 2002 to address those rates. And certainly, at a minimum, the rates should have included 17% of the total revenues to the restaurants then, not on square footage, because that's what the Mills report had in it. It was shortly after that Home Depot complained, and Home Depot wasn't the only one that complained. Linens, all three of the anchor stores complained about the water and sewer rates soon after they got the bills. Kohl's was able to negotiate a substantial reduction with the landlord, and the landlord pays a significant part of Kohl's water and sewer bills, just on negotiations. And Home Depot would have done something like that had that been available. But they couldn't. They wouldn't. The landlord and the sewer company would, well, it's actually the landlord, because the landlord's paying part of the bill for Kohl's. The landlord refused to do that for Home Depot. So in 2005, they sued, and we wound up here. And this has been pending since 2005. So another argument that's been made is that there are contracts out there and leases that have been made in the interim, and we should continue to allow the big stores to subsidize the big users because of leases that were entered into by the landlord with the tenants when the landlord fully knew that the rate was subject to litigation and could be changed. So that's not a reason to continue to prejudice the large stores because the landlord decided to ignore what he knew might happen. Now, Home Depot updated its filing here based on the fact that Independent Sewer and the landlord has never told the town board how many customers how many restaurant seats were in there. And so since we had nothing in the record other than allegations of the number of customers, we hired Delaware Engineering to nail that down. And they did in their report that they provided to you, which shows exactly how many restaurant seats are in there based on the health department records, and that's the way you would allocate cost. Mr. Guastella talked about Delaware Engineering creating a new plant and allocating it that way. It's not unusual for the capacity being needed by any particular customer to be charged based on the existing number of customers. And in fact, Judge Grossman pointed out that all the stuff regarding the development of this plant is irrelevant. The question that you folks are answering now is how should the rates be divided up now? And the costs that are there. They were incurred. Now we have to figure out how they're going to be paid. Mr. Guastella went in a lot criticizing Raftalis for its rate structure that allocated variable cost and capital cost. And essentially what Raftalis did was say, listen, we've got capital cost, we'll just put that in as flat rate in order to address some of the issues with respect to the variability of rates on the water side, and the rest of it we're going to put into a variable rate. The issue here really is not how much is a variable rate and how much is a fixed rate. The issue is how much are you going to charge the big stores for capacity versus how much you're going to charge the large users. Whether you charge that as a flat rate or variable rate or a combination of the two, which is exactly what Judge Grossman said you need to decide, and that's all he said you needed to decide, it really matters little. If Home Depot's rate was a fixed $80,000 a year, that's fine. If that $80,000 a year is paid by its water usage and an estimate of how much comes out of the nursery, that's fine too. The question, so all of the issues with respect to revenue stability and all those are really side issues that are trying to fog up what you all know needs to be done. What needs to be done is that the rate needs to be based on cost, and the cost to provide, as Mr. Guastella said, the cost to provide service to that customer. Well, the cost to provide service to the customer is some proportion of the cost to run the entire plant, and that cost is based on capacity or usage, assigned capacity. In his notes, he talks about Welch Foods versus Wilson, and the court said that the charge has to be based on the user's assigned capacity, and that's just what Delaware Engineering did. They went back, used the exact same numbers that Mills used in the development of the rates, and assigned capacity. So when things change, just like they did in Welch Foods, you have to change who you're going to collect the rates from. Also, I think that it's clear from Judge Grossman's decision, and Judge Grossman essentially issued a decision quickly because it's obvious what needs to be done here. And if we can work something out, that would be fine. But if we're going to ignore his decision, which says a couple of things. One, the PSC decision, the consultant's decision that the PSC decision was not applicable here isn't under review, even though that's a big part of what the argument is from Independent Sewer again. The PSC rate is different. It's set because fire flows for fire protection of the buildings is a large part of the fixed cost to the water company, and the PSC recognized that. When the PSC pointed that out, Home Depot did not object any longer. It was never on appeal, that decision by the PSC. They keep talking about a recent decision of the PSC. The PSC did not review the rate design in any recent decision, except to the extent that there was a change in the square footage that was reported, so that they looked at, they reassigned it based on the actual square footage. But the fact is, the buildings are the buildings. There's not a different fire protection requirement for the building that exists now versus the buildings that were planned. So there was no real reason to change the rate design. And your consultant found that it's not applicable, it's a different situation, and therefore we need to deal with what the rates are here and the requirements to provide service to the existing customers. And that's another thing that Judge Grossman pointed out. You need to set rates based on existing customers, not on the customers that would decide what the customer distribution that was in the original plan. I almost finished.
while you're looking up, the videographer, how long before the town get a copy of this tape? How long before the town will get a copy of this tape?
Is town hall closed tomorrow?
Yes, but you can drop it off.
I'll be in contact tomorrow, I can,
Okay, I'll talk to you after the meeting. So we can have it by Monday at the latest? Thank you. Fine.
I was going to do this PowerPoint presentation that was put together by Mr. Smith, who did the current rate design based upon the existing, the current customer mix. Now, I have the engineer from Delaware Engineering here, if you'd like to ask him any questions. But one of the things Mr. Guastella said, the engineer pointed out, Mr. Guastella said that the power cost and sludge removal did not fluctuate with water use, and the Delaware engineer says no, that's not accurate. Now, unfortunately, Mr. Smith got stuck in Denver and because of the snowstorm. He was supposed to be here today, and he was going to present this. I'm just going to go through it very quickly. This is his rate design structure. And the first slide, he points out that the existing rates don't recover revenues from the customers in a fair and equitable manner. Now, this firm has a national reputation. It is coming here as an expert, not as a representative. The portion of fixed revenue is too high, and retail customers are subsidizing the restaurants. He recommends that capital costs be through fixed, and that we recognize that the tenant mix at the shopping center has changed significantly since the system was designed. In the second slide, he points out what the problem with the 2012 rate is, that as it's set up, 25% of the flow comes from retail customers and 80% of the revenue. Restaurants provide 75% of the flow, but only 20% of the revenue is paid by the restaurants. I mean, this is what's obvious, and this is why Judge Grossman said, let's get this back to the town, because this makes no sense. The result is that the retailers are paying about $378 per 1,000 gallons, while the restaurants pay only $32 per 1,000 gallons. And of course, those numbers are approximate, because we don't know exactly the usage, but they're certainly well within range. We then proposed a capital structure, a rate structure in which 47% of the rate is collected through fixed cost and 53% through a variable charge. As I said, I agree. He's the rate expert. I'm a rate expert. I might have come up with something a little different, but the fact is that the real question is, how much do you collect from each customer, whether you collect it from variable or fixed makes very little difference.
You don't have the pages numbered, but on signs of a problem?
Sorry?
You don't have the pages numbered, but it's the third page,
Yes,
signs of a problem?
yes. No, I was actually up to, signs of the problem was where I was talking about the 25% of the revenues.
Yeah, I know.
Right.
That's, okay, so it's page 3 that we're talking, I want to know what the K stands for in front of gallon.
Kill is 1,000 gallons.
1,000?
1,000 gallons. That's an engineering term.
I'm not an engineer, I'm learning. I knew what the dollar sign meant.
Yeah, and actually, I see T gallons a lot. I don't know
Okay.
why he uses K, but I guess that's from South Carolina, who
Or
knows?
GPD, when it says
Gallons
design
per day.
capacity on the current capacity requirement.
Gallon
That's
per day.
gallons per
per
day.
day.
Got it.
I knew that one. GPH, we know that one.
So we go, if we go to the next slide, I think the next one's the current capacity requirement slide.
That's the,
I mean, that,
Next time, number the pages. Don't count the cover, guys.
yeah, unfortunately, it was supposed to be
On a screen.
PowerPoint. PowerPoint doesn't always put numbers on these things. The original customer mix, as shown on the left side here, the 70% of the revenues, 70% of the capacity was going to come from the restaurants, but the original rate design ignored that and put 100% from the retail, from the customers based on square footage. So, so there was a problem with the original rate design. It didn't follow the engineer's report. And what we're doing now is we're recreating the engineer's report to make proportional allocations of the capacity. So on for the current customer mix, based on the Delaware engineer's analysis, the restaurant seating would produce the capacity that they would require is about 45%. I'm sorry, the retail would be about 45%, and the restaurant's 55%. And actually, that isn't that far from what Mr. Dax had recommended in terms of the total amount of money that comes from each customer. And I think it's the next to the last page. It's the proposed rate structure. It comes down with $4.71 per gallon per day of capacity that would be charged through the fixed rate, and $63.96 per 1,000 gallons of wastewater. And he points out that the charges can be assessed on the tenants or the landlord. And we've recommended, Home Depot's recommending, that the charges should be assessed to the landlord, because the landlord is the one who has recovered the funds. The landlord is the person, I shouldn't say that. The landlord, please strike that. I don't know, the sewer company recovered the funds. Whether the landlord got them from the sewer company, I don't know. But the sewer company recovered all the investment that was made in it through the charges of the rates. However, the landlord is the entity that has changed the mix of customers. The landlord is the entity who has benefited from being able to use that capacity. And what Independent Sewer wants to do is to continue to charge the large stores like Home Depot for capacity that it and the landlord is using to serve other customers. Basic definition of what's unfair and untenable, and hopefully we will be able to move beyond where we've been for the last few years and come to some kind of a resolution. I might also point out, and this is my last comment, that if no one else cares, the rate to Home Depot, Home Depot is a landlord, so Home Depot will continue to have to pay rates. But the only real change in the revenue mix is that Home Depot would pay less, and then all the rest would be up for negotiations between the landlord and the tenants, and any adverse affects that were caused by the landlord entering into contracts during periods when the rates were subject to being changed could be worked out between the tenants and the landlord. Thank you. Is there any questions?
Yeah, just one. Over the past 2 years that you've been in the struggle with this, how much contact have you had with ISW to work things out?
On more than one occasion, I've made proposals to settle this, and essentially, since the last rate. Sorry.
Use the mic, please.
Talk
Sorry. Essentially, since the last decision, we've had no response with respect to any offers to sell.
Did you at least decide what the table is going to be, round or square?
I'm willing to sit down at any table. Home Depot is willing to sit down at any table. If they've got a preference, we'll go along with that.
As you know, during the
preference.
Vietnam conflict, when they went to discuss
I
the
remember.
settlement?
Yeah.
Okay.
Yeah.
I do have a question just for clarification, please. You said that can you explain that the company, the Sewer Works, has taken in $4.5 million, is that correct?
Over the years, since the rate went into effect, I should bring the mic with me, I guess.
Yes, you can.
Yes.
This was from the last time I was here. Since the rates have been in effect, and this was up until 2012, the after-tax net income for the period between 2002 and 2010 was $289,000 a year. And then the depreciation was $133,000 per year. After the 2010, when the rates were reduced, those numbers got reduced. You just multiply those by the number of years. Now, not every year they got their full amount, but they got pretty much close to it because the rates are pretty fixed. There's been no shown increase in operating cost or anything like that significant. And in fact, when your expert reviewed the rates, the revenue requirement went down because the expenses were less than was being, in part because the expenses were less. And so we get, for the first period, $3.8 million was available to pay for the, in my view, to pay for the plant. I know what happened. It was paid on notes of a term of less than 1 year, according to the 2011 tax returns, and another $778,000 after that, for a total of $4.5 million. That's more than what the plant, well more than what the plant cost to build. And they're still collecting something in the area of $390,000 a year.
And do you know what it cost them to operate that plant during that time?
But this was after the operating cost.
Right.
This is just the amount that's in rates for after-tax income and for depreciation. So that's after the operating expenses.
Okay, is that the new figure that the board did accept with Mr. Dax to reduce the amount?
No, these are actually before the board's rate. So actually, there's a couple of more
Well,
years. There's a couple more years that they
Mr. Dax made
made profit.
recommendations to the board. We accepted, not everything that was
Right.
proposed, but that was one thing we agreed upon unanimously. Is that number included in this, the lower rate?
No, this doesn't reflect the lower rate. This is before the lower rate went into effect.
Oh, so that's not an accurate number now. That's what happened
No,
with.
this is
up
what they,
till that
well, I'm
point.
saying they collected before that. Now they've collected more. They're still collecting something in the area of $300,000 a year for return on investment and depreciation, with your numbers.
Okay.
And
And that's after expenses.
And did you say that is there a fund, do you know if there's a fund for O&M or for any catastrophic failures, or you don't have we don't have access to that? Or you don't?
The 2011 tax returns showed something like $60,000 in cash and nothing else. No other reserves.
Okay, so $60,000 would be fair to say in 2011 that was what was in reserves.
That's, yeah, and I'm not saying that was held as a reserve. That just, when they did their tax returns, that's how much was in the checking account. I mean, that's usually the way the figures are put together. I don't have any first-hand knowledge other than the tax returns.
Okay. All right, that answers that. Thank you.
Thank you very much.
Thank you. Good evening.
I'm Daniel Stafford. I represent Eveready Diner Brewster, Inc., the firm of McCabe and Mack. I'll be less than 2 minutes, I
You might
promise.
want to raise it because you're a little taller than last gentleman. Good.
Better?
Better.
Okay, good. All right. I don't have the 46 years of experience that Mr. Natoli has, or the decades that Mr. Guastello has. I'm going on 7 or 8 years of practicing law, but in that short amount of time, I've never seen a more blatantly wrong procedural decision by a judge than Judge Grossman made here. I don't want you to be deterred by the fact that he sent it back to you for further proceedings. Home Depot challenged your 2014 decision, based 90% on square footage, 10% on usage, with the Article 78 petition. The respondents, including you, were not given a chance to answer. The judge did not have a comprehensive record in front of him. You didn't have a chance to explain your rationale clearly. So I don't want you to be deterred from adopting that same structure again, or going back to the pre-2014 structure, which is a 95-5 split. And that's really the main point I want to hit on, that I don't think the judge's decision should really be much of a factor at all in how you approach the proceedings tonight. One other quick note: if Home Depot's proposal was adopted by you, it would result in a 559% increase in our rates at the diner. which for a small business like ours is not sustainable. And I think Mr. Hollis is going to touch more on the possibility of this becoming essentially a ghost town of a shopping center if we go with Home Depot's proposal. So I'll leave that to him, but our number, according to ISW's calculations, is 559%, and I'm here to represent to you that that is not a sustainable option for the diner.
Can you tell the public what the numbers mean? I think it's around 13,000, around 130,000 and change.
For us, it's going to go from roughly 21,000 to 140,000 annually.
That means more than 500%.
It does.
Can I just ask you
Sure.
to explain briefly what you meant by procedurally incorrect as far as Justice Grossman's decision?
Sure. So when you
Which way should it have, in your opinion?
I think
What
the-
should have occurred and what didn't occur?
So typically, the way an Article 78 proceeding progresses is the petition is filed by the party who wants to challenge the town's decision.
In this specific case, that was,
That was Home Depot. Home Depot didn't agree with the 90%, 10% breakdown. One of two things then happens. The respondents, being the town and whoever else is affected, files a motion to dismiss based on point of law, meaning under no circumstances could the petition succeed. Okay. The other option is for the respondents to file an answer. Basically, the petition is a paragraph, numbered paragraph, succinct allegations. The answer that is filed is admit, deny, based on what is said in the petition, or some expanded form of that. And then also, along with the answer, the town gets to file the certified record of proceedings. In this case, it would have been a transcript, it would have been the exhibits. And once the judge has all of that, once he knows the parties' positions, and once he has access to everything that happened below, he can then make an informed, or he or she can then make an informed decision about whether what you did was rational and reasonable, or whether it was arbitrary. Here, the judge jumped the gun and granted Home Depot's petition without having access to all the materials that he should have had access to. And that's why it shouldn't deter you from adopting the exact same schedule. And if Home Depot chooses to challenge it again, hopefully we will have an opportunity in front of a different judge to make our case and to show why what you did is reasonable.
so what you're saying then is, so I'm a little clearer, you're saying that the respondents did not have an opportunity to respond to the petition of Home Depot?
Correct. We filed a motion to dismiss in response to the petition. And rather than simply denying our motion to dismiss and saying, okay, give me the record, give me your answers, he just said, no, not only am I going to deny the motion to dismiss, I'm going to go ahead and grant wholesale Home Depot's petition. Now, he didn't tell you, the judge didn't tell you what you should do, which is, had he done that, we would have had an opportunity to appeal to the appellate courts, which I think I'd put money on how that would have turned out. Judge Grossman would have been reversed. But that didn't happen.
So what you're saying is the procedure that was followed deprived the respondents from having the right of appeal?
Oh, absolutely.
Okay.
Absolutely. And it's a first-year law student can look at the CPLR and tell you that you don't even need a 1 year of law school under your belt. I mean, you can read the CPLR yourselves and determine that what he did procedurally was grossly incorrect.
And can you identify the respondents?
There's several, there's,
Town
The
and-
respondents for the town and all of the tenants.
the town is basically everyone in the,
I want the public to know, because sometimes
I'm
when you're
sorry.
watching these shows, you don't
Right.
know.
yeah, yeah.
Yeah, the respondent are the town and 17 or so tenants.
And how would you respond to the fact that on page 6 of Justice Grossman's decision, it says, "The court notes that this determination is not conclusive on the issue of how sewer rates should be calculated and charged, square footage versus usage versus a combination of the two, or some method that produces, quote, fair, reasonable, and adequate, close quotes, rates for all users. This is something that must be addressed by the town board."
Well, that essentially opens the door for you to decide however you want to decide it, in my opinion. I think, like I said, he jumped the gun and granted the petition and found that this was arbitrary without actually examining whether it was arbitrary. I don't agree with the opinion. And I think that that particular passage you read opens the door for you to come back, deliberate again, hear the high notes again of what each of the parties' positions, and choose a rate design that you think is fair and reasonable. And here, this I'm not going to rehash what Mr. Guastello said, but this plant was designed. Actually, the ISW had to build this plant bigger because of the immense square footage, the 500 parking spaces that Home Depot demanded. They had no choice but to overbuild this, and it cost a lot of money to run. So who's the logical person to pay those ongoing maintenance costs? The tenant that enjoys the most square footage and the most parking spaces. I mean, it's a very rational way to arrive at a rate structure.
In your application, whoever's application for the motion to dismiss, didn't contain these essential facts?
It contained the facts, but it didn't. We didn't have an opportunity to submit an entire record to be able to point to certain evidence and say this is why it was rational, this is why it was built. There were a number of exhibits attached to our motion and attached to the petition, I believe. But it was. I mean, as you know, this has been going on a long time. There's a lot that goes into this decision, and you took appropriately so, took your time in deciding what was reasonable and what was correct. The judge didn't do that.
So it would be your position that when the judge took what was characterized by Mr. Natoli was an appropriately, expeditious, a quick period of time to render this decision, that it was one which was not appropriate under the circumstances because he didn't have the correct amount of information.
Correct.
If we indeed make another determination at this point in time, or at some point in time, regarding the fact that we think the rate should be whatever we say, we either adhere to our original decision, or we decrease, increase, what have you. What would then happen? Would there be, an aggrieved party would then file another Article 78? What would happen?
I think Home Depot has the resources and the motivation to continue fighting this until an appellate court says, no, the case is closed. And because Judge Grossman remanded it to you at this point, we didn't have a chance to take it to the appellate court and argue our case there. So unfortunately, we're dealing with a litigious party who is going to fight this until a high court says, I'm sorry, the town was reasonable in what they did. I think that's probably where we're going, unfortunately. And Mr. Natoli alluded to that tonight, that he's prepared to continue challenging as long as it takes. And there will come a point at which an appellate court will say, no, the town was correct.
But absent, really, the focus of my question was more or less that should there be a new determination, and then whoever the aggrieved party then proceeds in this manner, then the successful party would then do the motion to dismiss. If the new Supreme Court judge follows the course that you believe was the correct procedural course, then at that point we would move towards the town, or whoever is the party getting appealed against, then having the ability to move forward in that process that you're claiming is the correct way to proceed.
I think at a minimum, Judge Grossman should have allowed everyone to respond, which he didn't do.
Okay.
At a minimum. And I would hope that the next judge, whoever is, in the event there is another judge, at a minimum will give the aggrieved parties that courtesy.
Okay, very good, thank you, I appreciate it.
I emailed a letter to Mr. Hay earlier in the week. I'm not sure if all the...
We
got
share
it.
all the
Great.
documents, but if you want to provide it again,
If you
just in
like it,
case.
like a hard copy, I got some in here.
Okay. Waive the rules, accept these additional, which I believe we
I'll
already have.
second.
All in favor?
Aye.
We never get checks in the mail, but we get these types of things all the time.
Good evening, Mr. Supervisor, members of the board.
Good evening.
My name is P. Daniel Hollis, law firm of Schamberg, Marwell, Hollis, and Drasack and Laidlaw in Mount Kisco. We represent TL Cannon, the franchisee of Applebee's in the shopping center. Mr. Stafford and Ms. Hudak hit on the major point that I wanted to make, and I made it in my letter, which is already a part of this record, my letter of March 17th. Judge Grossman did not make the proper decision. I'm not an expert in much other than this. I've been doing this for it's my 5th decade of standing in front of boards like this or in front of courts. And while I don't profess to have the economic or scientific background of Mr. Natoli, I know unfairness when I see it, and I know a truck or a bus about to run over my client who has been thrown under it. That's for sure. And if you go to the last page of what Mr. Natoli gave you tonight, you see all 8 wheels of the 18-wheeler, or 18 wheels of the 18-wheeler, or the full Greyhound, because it says that Applebee's, under the proposed bills to the tenants, Applebee's would be paying $94,945 more a year. That's not sustainable. Mr. Stafford correctly mentioned the phrase I used, you're going to have a zombie shopping center. Homeowners are worried about zombie neighborhoods where there are zombie homes because of mortgage foreclosure. There's no way that you can sell enough breakfasts at the Ever-Ready Diner or enough family meals in Applebee's to make up the increase that Home Depot is proposing. What I do know, what I am expert in, I would humbly submit, is the law. And Judge Grossman was dead wrong. Judge Grossman should have, as Mr. Stafford said, remanded the matter for answers to be submitted by all respondents. There was not a full record. The town's record was not part of this proceeding. All of the minutes of these proceedings, all the submissions made in chronological and complete order was not before him. Mr. Natoli said in his letter, in his submission, the town must now make a new determination that implements the Supreme Court's order. That's not what Judge Grossman said. He went through an analysis that took issue with the way you did it, but then at the end, and this is why what he found is not the law of the case, a phrase that lawyers know when something has been decided, it's the law of the case. There is no law of the case, because while he criticizes what went on, at the end he throws up his hands and says, Ms. Hudak quoted from it, the court notes that this determination is not conclusive on the issue of how. If he found fault and he wanted to establish law of the case, he would have said, and I direct that the town not implement any of the tools that it used, or make use of any of the tools it used in reaching the decision it reached in establishing the 90-10 formula. Also, what I do know after doing this for 40-something years is that the courts give great deference to legislative or administrative bodies when they are tasked with making a determination, be it the PSC when they make their determination, or be it this town board when you're charged with being the regulatory body that sets the rates here. The court gives deference. Judge Grossman said, yes, I'm giving you deference, you go figure it out. And I would respectfully submit that if the full record were before the court, and I believe me, unless the page 5 of the Raftelis report is how you come out, there'll be an Article 78 filed by Home Depot, and the full record, I would suspect this time, will be submitted, and there'll be a determination. And whoever makes that determination at the Supreme Court level, as Mr. Stafford said, will be in the appellate division, and absent a unanimous decision there that would preclude an appeal to the Court of Appeals, the losing party there would have to make a motion for leave to appeal to the Court of Appeals. I know from my own experience that the success rate of that is 5%. So the case will probably end in Brooklyn someday, probably, I would suspect, about 3 years from now, when it's all over and said and done. But your job is now before you. So 523%, that's the increase that Home Depot's bus has targeted on Applebee's. That's what they're asking you to do. And that is just not fair. I know unfairness when I see it. I know a decision that's not based on the full record when I see it. And I know when a full and fair application has been made, and I know when deference ought to be given. The fact that, and this has been admitted, that the PSC finding using square footage was outside the box. It was outside the norm, because they usually do use usage. I'm not an expert, but that's my understanding. In the same way, you too can step out of the box, because this shopping center's sewage treatment plant was overbuilt because of the DEP. And because it was overbuilt, that cost was put upon, and for the most part, on the largest square footage of a building that takes and uses the most parking spaces. So I would respectfully submit that the decision that this board made 2 years ago was proper then, and if you made it again based on the record that the ISW has put before it, and even based on what Mr. Natoli has put in, fairness, precedent, and deference requires you to make the same decision. Thank you very much.
Mr. Hollis
Yes.
and Willis, if you can, when we speak about, when you just said that, then the appellate court would then look at the full record. Does that full record include the determinations that we made, or how we moved forward when we made our first determination? So
Well,
what we
Mr.
considered in
Natoli
that-
said he's reserving all his rights, so I would suspect that the record would include, if he's the petitioner, I don't want to speak for him, he's a very, very good attorney. I'm sure he'll be complete in what he submits, because he's always done that. But I would suspect that there will be references to the earlier proceeding and a distinguishment of the two decisions if they differ, I would suspect.
Okay, before we go to a second round, I'm gonna limit 1 minute to rebut, because we can go on here all night. We've heard much of this before. We're gonna hear it again in a few weeks when we make our determination, whether it's one side to the other. Someone's not gonna be happy, including us, because we're gonna be right back to square one. So if there's a rebuttal, I'm gonna have to give everyone at least 1 minute to rebut.
I don't think I'll rebut myself,
And
I'm good.
I mean, I want to be fair to everybody, but, you know, we've given everyone ample time to make this case. So if Rick speaks, everyone's entitled to 1 more minute.
Before my 1 minute starts, I just want a clarification. I don't think there's any objection for this. Insofar as the record is concerned, I just want to make sure that it is clear. It's not only the information that has been given to you with respect to this application in light of Judge Grossman's decision, but it is all of that other information you've had previously as well, which is voluminous. But I think it's very, very important, as was said by learned counsel who represent restaurants. It is very, very important that this time around the court does have the entire record, which it did not have the last time, and that's very, very important. So I just want to make sure that there's no misunderstanding that all of that other information that was submitted will be part of the record here.
So the information that had, and once again, I'm not opining anything about Judge Grossman's decision. All I'm saying is what Mr. Stafford had said regarding had the court had all of the information. When he said that, that is all the information that would then be reviewed in any application, should there be an appeal of our determination.
Absolutely, 1,000%. And when you think about it, you made a decision, the court made a decision on the merits without the record. That's what the procedural error is. Didn't have the record. All right, so long story short, I know I have 1 minute. I just want to very quickly point out a couple things.
He's not paying attention. You might have
All
to
right,
pay
so
him.
No, he doesn't.
no, I think
I'm listening, he's
all right,
way
I think
early.
Tom.
Exactly.
all right, there's been a lot of discussion in terms of usage and versus fixed cost and everything else. Just for clarification purposes, remember what you're dealing with. It's not a hypothetical situation. You're dealing with an open-air garden center that Home Depot has that has rainwater that goes in there, that has irrigation for plantings and things of that nature. That water goes into the sewer system. That's not usage. Think about it. It's not. All right? So this artful kind of box that you can put this thing into, you cannot. And that is precisely the reason why the Public Service Commission went in the direction that it did. And Mr. Natoli fought for 10 years to undo square footage before the PSC, and he lost, and he gave up. This one, he's still fighting that same battle. All right, so I think it's very important that you realize that. The second thing that I think is important, and it's just a correction of fact, it's not a rebuttal. Home Depot, when it opened, it said, "Get me water and sewer." Home Depot was not charged water and sewer. They said, "I want to open by a certain date." All the paperwork was not done. The rates were not set. These utility companies had to give them, and did give them, free of charge, the utilities. So it's not, it's not like we've been leeching these people for all these years. And I think lastly, and I think this is very important, and I don't want to dwell on this because we'll be here for another 30 hours and you don't want to be here. Home Depot knew that these were private utility companies that had to be established. Why? Because there was no infrastructure here in the town of Southeast. So you had to establish a water company and a sewer company. These were independent entities. It was disclosed what was going to happen in terms of the rates would be set by the appropriate regulatory authorities. That's exactly what happened. Thank you.
Mr. Tolle, you get a minute and a half.
I'll try to be very quick.
Minute and a half.
Okay. First, we never fought over the square footage rate at the PSC for 10 years. It was in the original complaint in 2005. After the first decision, which was never issued by the PSC about 18 months later, it was not even appealed. So to say that we've been fighting for the square footage rate at the PSC for 10 years is simply wrong. Secondly, yes, there was some free water and sewer at the beginning. I think probably certainly less than a year, probably less than 6 months. But for that free water and sewer, the sewer company's been charging $260,000 a year from 2002 to 2010 for a single store. There's no rate anywhere in this country that is even close. And then the third thing is, yes, Home Depot should have known, and therefore did know because it's in the papers, that the rates would be charged by a private water and sewer company. But it had no way to know that this company was going to capitalize 100% of the plant. They could have capitalized 0, 25%, 10%, and in fact, the intent of the parties, Linens and Things, Home Depot, and as far as we can tell from the settlement with Kohl's, all of those parties felt that the much smaller percentage of the plant would be capitalized in the rates.
Now, you're on our time. We get a minute and a half.
Okay.
What do you mean by capitalized?
Capitalized, well, what's driving this rate is that the company came in and said, okay, the plant costs $3 million, and we're going to include that in rates. So if you include that in the rate,
You
which
mean
is
ISW said that?
ISW.
Gotcha.
Yes. So if you include that in the rate, then you get approximately 11% as a return on that investment, $300,000 a year. And then you get depreciation on that, another 3% approximately, give or take. The plant, there is simply no other packaged sewer plant, any other sewer plant in the state of New York serving a shopping center in which where the landlord charges capital profit, return on its investment and depreciation to the tenants.
Okay.
And the last thing is that we're recommending a rate that goes to the landlord, and therefore we're really not recommending a 500% increase in any of the restaurants. The landlord should be able to work that out with the.
So what you're saying is on the last page of the Raftellus handout, that would have been the
Bill
PowerPoint.
comparisons.
You're saying that when that shows that hypothetically, Eveready Diner will be spending $107,505.61 more. What you're saying is then Eveready Diner should say, hey, landlord, I don't want to pay that. I want you to reduce my lease, or I want you to have a new lease where I would only pay, instead of $127,000 roughly, because the current total that they're paying is 21. I want you now to absorb some of that cost because I'll stay here. What the heck? I'll go for 50. That's what you're saying.
It's something like that, right? Exactly. And if you look on the right side of the table, it has the building. That would be building 5, and the building 5 rate would be the full rate that we show. And the reason that rate came up is because that's the amount of capacity that the restaurant would have been assigned had all of the restaurant seats that now exist be charged in the original.
Right. So essentially, your position then is that the landlord should renegotiate and shoulder costs, and if therefore if the landlord doesn't do it, it isn't it wouldn't necessarily be Home Depot's fault that whichever it is who said they have to leave Eveready and Applebee's, it would essentially be the landlord's fault because the rates were, got it,
We're
okay.
not the ones that capitalized the $3 million. I mean, the rate, the overall revenue requirement would be about 37% of what it currently is, and so all the rates would be 63% less.
And it's your position that similar sewer plants in this area don't or whatever you want to call them, aren't in the position of doing that capitalization, therefore, it's the landlord's.
They don't. They capitalize it. The landlord capitalizes it. It's on his books, but he doesn't pass it through to the tenant. I think in the last hearing, Mr. Nadell said that the only other shopping center that has a transportation corporation within this town that it's charged as a CAM, and the CAM charges almost as far as I know, and I'm not a CAM expert. This is going beyond where I'm an expert, but are typically maintenance and replacement, not additional profit on top of on the cost of the shopping center.
Very good, thank you.
I just have a question maybe for Will. Everyone's saying Judge Grossman didn't have the whole case. Is there a reason? I mean, did someone neglect to send it to him?
No,
or-
no, no. What happened was when the petition was filed, the respondents, all of which would be the town and ISW and all the users that had taken part in the proceeding, filed a motion to dismiss. And when the judge decided the motion to dismiss, normal procedure would have been said, I'm going to deny your motion to dismiss, file your answers, and file your record. What Judge Grossman did was he basically granted the petition instead of just denying the motion to dismiss. He granted the petition and sent the case back to us for further proceeding, back to the town board. So he never had the full record of all the proceedings that we had previously, all the hearings, the extensive documentation, and didn't have essentially the rationale as to how this board made its very, it was I think, if I do say so myself, a well-written decision.
How many years of experience do you have?
Thank you.
35. That's what
I didn't think you were gonna make a comment. You reneged, just like a lawyer.
yeah,
No, go ahead.
It'll be very brief. See, what Mr. Natoli just said about, according to page 5, it says Applebee's 94,945. It doesn't say landlord. And what that bus is doing, it's not going to kill me. It's just going to prolong my death by injuring me, by putting me into litigation or controversy with a landlord. That's kicking the can down the road in a way that's not acceptable or appropriate. And that's my final comment.
Mr.
Thank you.
Hollis, I'm just curious, and I just asked Mr. Natoli a question regarding the fact that, whether now the landlord will be in a position, or pardon me, that the various entities, and in your particular case, Applebee's, would be in a position of saying, well, under the circumstances, we're going to, quote-unquote, renegotiate our lease or negotiate a lease so that the landlord would shoulder more of the cost. And I know that you're not representing Applebee's except as an attorney, but do you think that that would be a viable proposition where Applebee's would say, hey, listen, either you renegotiate it or we're not going to do it, or would Applebee's then say, we're out of here?
Well, it'd be one of those two things, because that's the point I'm making, that we're being put in an adversarial position with a landlord, because it's adversarial for $100,000 a year. There's no way that doesn't become adversarial. That's not small change. So the can gets kicked down the road, and the bus makes another trip around the track to get a better shot at you. It doesn't solve the problem. It creates more problems. I think fair, reasonable, and adequate is what the court said you need to look at. Everything else is window dressing. Everything else is not the law of the case. So that pushing it off to make it a landlord-tenant issue is a way for Home Depot to get out from it under the expense and make it Eveready's problem and Applebee's problem, and whoever else has their rate go up. And that's not fair either.
And Mr. Stafford, I'm going to make a move and just ask you, would that also be the position of your client, do you think?
Yes, we're not in a position to tell the landlord, you have to renegotiate our lease, you have to adjust what we pay on a monthly basis and And by the way, you pick up these costs that Home Depot was paying before, even though Home Depot is the one that was really the reason that for the larger plant. We're not in a position to be able to make those demands, and Mr. Hollis is correct. It puts us in a position of fighting with the landlord now, whereas we don't think they've done anything wrong.
Very good, I appreciate it, thank you.
Can I ask you one question? It's on
Sure.
our time now, because we're entitled to a minute as well.
Sure.
On your client, that's Eveready Diner?
Mm-hmm.
What does his lease say, how he would be charged?
So, what's the
How-
question again?
In the lease that you signed with the landlord,
Right.
how does it say these utilities would be split?
I haven't looked at the lease in quite a while because the lease hasn't been an issue.
Well, but I used to be in business, and I had leases with my tenants, and I identified what the rates would be. Was it ever in yours? Are you aware? Okay, I'm hearing the word yes.
Yeah, I can't speak to what's in the lease because I
I'm
don't
not
have it in
putting you on
front
the
of me.
spot, I'm just trying to know. when
What
you-
you're saying is a likely scenario.
No, I mean, basically, I had a small shopping center, only 5 stores.
Right.
Okay? And I wrote in everybody's lease where they could park, there was rules and regulations of the parking lot, et cetera.
Right,
But everyone identified there what their common charges would be.
right. And the common charge,
A common charge to me is what we're talking, you got water, sewer rates, whatever.
My understanding is, as an exhibit to the leases, are the tariffs for the utilities.
For the what?
For the utilities, the rates. It's an exhibit to the lease.
And how, okay, but how? But is it based on square footage, based on water usage?
It's what the rates are.
What the rates are.
Whatever the rates are.
What you're setting. Our utility costs in the lease, if I had to put money on it, would be you pay what the rates are, and what we're here for tonight is determine that amount and that design.
So what, I get that part, but what is it based on?
It's based on what you decide.
Or what we decide?
What happens?
We pay the rate, whatever the rate is, and we're here tonight to determine
Oh.
what that rate is. So it's not broken out in the lease, you're gonna be paying a certain amount for usage versus square footage. Basically, it's tied to your decision. It's directly, what we pay flows directly, excuse my pun, flows directly from what you decide.
It's like buying a house not knowing you're in a homeowners association. Okay.
Well, I think the argument
I
would
get
be
it.
that there was an expectation based on what they had.
Right.
And now the expectation is gonna be skewered by
I
what
get
might
that,
be.
but
Yeah,
I
we've
just
been
wondering-
doing basically the same thing for 14 years. Imagine yourself investing in a restaurant, purchasing booths, purchasing kitchen equipment, hiring a staff. You make tens of thousands, if not hundreds of thousands of dollars of capital improvements in reliance on a certain rate structure, and only to have that potentially jerked out from under you.
Okay.
Got it, thank
Got
you.
it. Thank you.
Tony, can I make one comment?
Yeah. Yes.
No.
Because I think we'd be remiss if we didn't mention this, and I do not expect an answer tonight, but I personally have gotten about 10 calls or seen people in person who have commented on the odor up at Home Depot. Or actually, you can smell it at the Eveready sewer.
Well,
not at Home Depot.
The plant itself, not.
The plant, it's
It's
sewer
up by
plant,
the
but.
Home Depot, unfortunately.
But it's people who shop at Home Depot or at the Eveready particularly, because that's where I know a lot of people go to eat. I know because people ask all the time and we've been told different things, but I think, one doesn't have a lot to do with the other in one way, we're rates, but this is something we would really like to see corrected. It's really important for the quality of life. And I would think it would be very important to the tenants because it's not fun to go and eat in a restaurant when you smell a septic smell outside. So I'm just making you aware of it in case you're not, because I think Tony's gotten complaints too.
And unfortunately, I've smelt it.
And
do-
I
do
have
go to the
smelled
shopping
it
center,
as
so.
well. So,
But that's not part of tonight, but
no,
thank you for
but
bringing it up.
I'll get
Okay,
yelled at if I don't.
Public service.
Anyone from the public wishes to speak to this matter?
I know.
John Lord. I just had some questions on is stormwater remediation part of the flow into the independent sewer works? No? Okay. And In rate setting, does the town get all the fixed costs from Independent Sewer Works in order to come up with the rates that they propose? And if they do, would the capital costs that Mr. Natoli said have been part of the rates, would they be broken out? Because he said you haven't seen since 2011 what the 2011 tax return, what was being held. I just wondered what would happen.
Well,
I don't know the answer to that question, Tony.
can't say, but I am going to ask after this meeting.
Because perhaps the rates would be a lot less if those capital expenditures had already been paid off.
I'm going to be asking, I'll do it on the record now, that I'm going to be asking if they can, ISW can provide us with the tax returns up to date, 15, so up to 14, 12, 13, and 14, at your earliest convenience would be helpful to the board.
And the other question I had was wondering if, okay, well, that's all for now. Thank you.
Okay.
Tony, can I clarify one thing, because John brought up a really good point, and I've heard two different things now. The parking lot at Home Depot, as far as stormwater runoff, from both parties, does this go into the sewage treatment plant, or and same with watering plants, does it, or does it not go into the, and I don't mean little, I mean, does it really funnel into it, or?
I thought I heard earlier.
I think just for clarification purposes, so that everyone understands, the runoff from the garden center, which is the open air, the rainwater as well as irrigation there, that does go into the sewage treatment plant. As far as the stormwater runoff in the parking lot, that does not go into the wastewater treatment plant.
Okay.
One of the provisions, however, with Home Depot for this whole deal was that they wanted parking that was in excess of that which was required by the town.
Okay, I've been just told by the town attorney that I erred by allowing other members of the public to speak. So the regular public portion is, you can speak later on under recognition of the public if you don't mind. Sorry, not a public hearing. I treated it as such, but was not advertised as such. I still don't know the rules. Okay. I believe we're done hearing what testimony we heard tonight. Now, I'm going to give us a little bit of time. I do have to ask for some additional paperwork. I do want to speak to both parties, myself, board members. You're entitled to call either of the two parties if you have any questions. I'm going to set a date for May 7th, where the town board, I'm going to speak to all my colleagues offline individually. We can't, as you know, unless we have a public meeting, which we're not going to have on this matter. Each one can sit back, make discussion. I'll be in contact with them. They can be in contact with one another. I'll basically will have a poll of my colleagues before May 5th, and we'll have a resolution prepared for that evening as to which way the town will go with the future of that. So May 5th, it's a Thursday, same location, 7 o'clock in the evening. It will be a resolution by the board of where we're going to go on that matter.
You said May 7th and May 5th.
May 5th.
May 5th, sorry. May 5th, it's a Thursday. So that's when it will be brought up next with a resolution, how the town is going to move forward on the issue. Thank you for coming.
Thank you.
You can stay for the rest of the meeting.
Well, we'll bang.
Okay. And Mr. Natoli, you're going to provide us with some documentation tomorrow, well, whenever you can? That one thing
The points that you were.
you had, that
No, I commented everything.
Yes.
yes. Provide them to us so we have a complete record?
Town
Thank you.
hall's closed tomorrow, but
You can email.
I misunderstood your letter. You asked for a court reporter. I thought they were supposed to bring a court reporter. They missed it all completely. We don't have a court reporter, but it's recorded.
It's on,
Yeah, it's recorded.
if you want to,
No, in your letter, you said, bring a court reporter. And everybody missed it.
The letter was directed to both parties. Neither party got a court report.
okay, well, look, it,
We can make it off the
Well, we
tape,
have it,
take the
yeah,
transcript
yeah.
off the
yeah,
tape,
you have,
whatever you-
it doesn't change for anyone. It's probably better than a court reporter, because you got it
Make
live.
a transcript off the tape.
Well, that's actually what I was asking. You want the transcript off the tape or?
No, no.
This, so the tape.
Well, Yeah, I
Well,
mean,
was
we're
this something that was required by you, Tony, or?
It was a letter, scheduled letter, I suggested that they have all of them.
Oh, okay.
terrific.
So we don't necessarily, well, we don't, okay.
This is no matter, this is going to be part of, whatever record needs to be made.
Gotcha.
When this is reviewed by a court.
The camera's still rolling.
Wait, no, we suggested maybe, if it didn't happen, this is the second best, maybe even better than a court report. No,
Very good, thank you.
Thank you.
And the camera.
I am, that's why I asked earlier when this could be ready, so we'd have more time to review it as well. Okay? And you can send it by email tomorrow, even though the town is closed. We still take emails every day of the week. Okay, again, thank you for coming.
Thank you.
Thank you.
Okay, I make a motion now to go into the regular portion of the meeting.
Second,
All in favor? Aye. Waive the reading of the correspondence.
Seconded.
All in favor?
aye.
Approve of the voucher list, $959,370.99. So moved.
Second.
All in favor?
Aye.
Setting of meeting dates and public hearings. All meetings will be held at 1360 Route 22, Brewster, New York, at 7 p.m. unless otherwise noted. Thursday, April 7th, 2016. Thursday, April 21st, 2016. So moved.
Second,
All in favor?
aye.
4, waive the reading of the budget transfer.
I'll second it.
All in favor?
Aye.
Number 5, local law, food trucks, amending Town Code Chapter 103, peddling and soliciting. Bob, thank you for all your input there, and Peter Bell, you're basically the mover of this here on the board. Now therefore be resolved that the Town Board of the Town of Southeast hereby adopts local law number 3 of 2016 pursuant to the Municipal Home Rule Law to amend Chapter 103 of the Town Code, peddling and soliciting, by adding a new Article 2 thereto to authorize the issuance of a limited number of vendor permits for the operation of food trucks within the Town of Southeast, and be further resolved that the town clerk be and is hereby authorized and directed to A, enter said local law in the minutes of this meeting and in code book of the Town of Southeast, and B, give due notice of the adoption of said local law by filing such with the Secretary of State of New York within the time required by law. So move for discussion.
Second,
Okay, brief discussion. Again, thank you, Bob and Peter Bell, for your input in getting this to the board. I think we spent a lot of time on it. Personally, didn't think we needed it, but we got it. So, it's going to be posted, it's actually posted on our website. It'll be official when it's approved by the state. I just want to reference the dates that are in the local law about when people will apply. We will start taking those applications immediately, because this says November. So Michelle, instead of a November date, you'll use an April date, okay? And where it says December, you'll use a May date, okay? To keep it in sequence. So in other words, residents of the town have priority, and then 30 days later, outsiders are entitled to. This way it keeps everything in. I think for the first year, because of the way it is, I'm making a motion now that we just use the 50% rate, like the half-year rate, would that be fair to everybody? Is that part of it? I can do that?
Because it's half a year.
Yeah.
Okay. So when you come and make your application, it actually, it'll be based on from July 1 to December 31st, but once you get your permit, and it's, again, approved by Albany, you're going to get a free month. We don't give a lot of things away for free, but food trucks, whatever. So anyone that goes forward, I do wish them luck. Anyone else?
do we need a motion to,
I'm sorry, go
I
ahead.
do.
A motion to, well, wait, I made
well,
it.
just to modify what you just
Well,
said?
well,
Well, the local law is drafted in such a way as to give notice on the full year basis how these would work. I would think that in the current year, I don't think it necessarily requires, a month of providing senior or preference to
but I'd rather do that.
residents or not. But that's fine, you can do that, but that's, I think you should do that
Separate?
outside of the, it's not gonna amend the local law.
No, I'm not amending, I'm basically, how about the resolution itself?
But I wanted to make another point is that
Okay.
you, since we've set up the local law so as to have the fees in our fee schedule, you're going to have to move to amend the fee schedule.
Tonight, too?
You can do that.
Yeah, I don't have it. Okay,
But the reality of it is that if you do it next month.
next meeting.
or the next meeting, which is only 2 weeks away. It's probably gonna be long before anybody gets a permit in place. So.
There's a procedure, we'll have everything posted on the internet, and again, we'll just delay each one and do it on 6 months. And for the next meeting, we'll have the rate schedule, which we already know, but we'll just do it officially. So, right now, what am I doing then? We're just passing the resolution as,
You're adopting a local law as it stands.
okay, with the resolution, okay. So, with no further discussion.
No, I
all-
have want to discuss.
Say it again?
I have something to say. on
You
this.
hungry already? Jeez, go ahead.
No, I will be voting yes on this, and I'm glad we're going to try something new. However, I just want to state now that if this results in lots more litter, because this town is a mess, and which I'll talk about at the end because of cleanup day, I will be the first person to propose that we revoke this. So I just want people to know that it's really important to me and to people I've spoken to that everything remains clean, okay?
Well,
And
until
we
we.
do
re-
have a provision in there.
I
It's
know,
on-
I know.
Until we revoke people driving through our town, throwing crap out their window that didn't even originate in our town, I might agree with you. I mean, I get calls quite a bit. I mean, people say we do nothing. I don't agree, which I'll discuss at the end. But I'm
Right.
telling you right now, the garbage that's generated in the town is not necessarily, I mean, it was a concern at the bottom of Brewster Heights, that gas station, they were
Right.
gonna generate whatever.
Right.
And I made the comment that, Will and I went out one day, he got a coffee, and I don't think he took a sip, a mile down the road. So the cup didn't get discarded between that gas station and, 200 down the road where they saw all this new litter. So anyway, on this issue alone, all in favor?
Aye.
And the other, I'll just bring forward at the next meeting. But Michelle, you can start the application, you can start moving it. Okay? Okay, number 6. Resolution, Putnam County Real Property Tax Services. Now therefore be resolved that the supervisor is hereby authorized to execute and deliver to the county a Putnam County Real Tax Service contract dated March 7, 2016 for the 2016 tax year in the form and substance annexed hereto, and be further resolved that the town clerk shall forward a copy of this resolution to the assessor forthwith. So move for discussion.
Second.
Discussion.
The only correction I have is the town clerk certification has held the 21st day of March, 2013.
24.
So it should be,
Where are we at?
Typo.
it's a
It's the
typo.
wrong, it's a typo.
I don't know if
Should
that
be
has-
20. No,
Oh,
that's one.
geez, I don't read that page. Okay. Said for it held the 24th
And
instead
it's
of.
the 24th day of March, 2016.
Okay, as a mover, I'll accept the amendment. Who was the seconder?
I'll second.
You accept it as well when you change 2016? So it's going to now read the 21st day of March
No,
2016.
24.
24th.
It says March 21st.
Okay,
It should
March,
be
it's going to
24.
read March,
That's not really part of the resolution, that's only a document that the clerk uses to certify the originality, and she can change that without any problem.
okay.
Which is
Okay.
fine.
When we use a template, unfortunately, things like that happen. Sorry.
I've been guilty of that many times.
Okay. Okay, all in favor?
Aye.
Okay, number 7, resolution to establish performance bond amounts, Durante Rentals, 11 Fields Lane. Now therefore be resolved that the bond amount shall be established for the project set forth below. Durante Rentals, site improvements, $29,640. Landscape and erosion, $9,640. And be further resolved that a certified copy of this resolution shall be transmitted by the town clerk to the planning board secretary and the building inspector forthwith. So move for discussion. Discussion. All in favor?
Aye.
We will not be in, but they'll have it on Monday. And by the way, you're not going to hear, by the time you hear it, Town Hall is closed for Good Friday, which is tomorrow. Okay, number 8, resolution, establish performance bond amounts, space on the farm, 400 and 406 Star Ridge Road. Now therefore be resolved that the bond amount shall be established for the project set forth below. Space on the farm, site improvements, $53,500. Erosion and sediment, $4,400. And be further resolved that a certified copy of this resolution shall be transmitted by the town clerk to the planning board secretary and building inspector forthwith. So move for discussion.
I'll second.
Discussion. All in favor? Aye. Number 9, It's a resolution for TOSAC, T-O-S-A-C lease, 67 Main Street. For, wow, many, many years. There's been proposals for 67 Main Street. The proposal, I think, was a $3.8 million bond to move forward with turning 67 Main Street, which is the old town hall, the big white building next to Eagle Eye, and in between, of course, the library. They now have, with the town, a long-sought lease for the first floor, which is the downstairs, where they currently have their cultural arts programs, well attended by many people. And this lease also gives them now the third floor to begin to renovate it as a theater. So they are willing to take any and all donations that are coming forward. I want to thank Will for getting this done. I know many of the members, actually all the board members, probably except for myself, are very into the arts and have pushed for this for a long, I'm only kidding. I mean, it took a while to get this done, but it's done. I believe they're quite happy. They can move forward. And I do wish them the best. And again, thank you for its preparation. Comments?
Yeah, I think they've worked exceedingly hard on this. It's a real asset to the community. I think this will help them get grants, and I wish them all the best and a lot of success on this. I think it will help the village as well. It's the Cultural Arts Commission.
And do you want to identify
How many
TOSAC?
years is the lease?
Town
At
of-
least it's 10 years.
It's the Town of Southeast Cultural Arts Coalition.
Coalition? Okay.
Yeah,
For 10 years.
10 years.
10-year lease for them, yeah.
And believe me, we haven't used that building in probably, well, we've used the building, but not the third floor. The third floor has been vacant for quite a long time. They have great plans for it, and now that they have this lease, I'm quite sure it'll be framed somewhere, and they'll be looking for donations, like I said earlier, and we look forward to that happening.
I know that a few years back there, remember when there was that movement afoot to have the approval for renovations from I think it was $3 million.
3.8 million?
And what happened essentially was it was voted down. At this point in time, this is a very dedicated group of individuals who then took the approach of doing it slowly but surely, and they're dedicated. I've seen the work they've performed so far. They've culled together a wonderful organization of people, including architects, a lot of volunteers. And now I think it's probably up to the members of our town and beyond to help out with creating what could be a really nice facility.
Yeah, this is really win-win because the renovations will not be at local taxpayer expense. They will
Right.
be fundraising and applying for grants, and it's really, it's going to be really wonderful, I think.
Okay, so, but this says resolution, Tony, but this means you're just going to sign it. We don't need a resolution? Because I didn't see
Wait, didn't
one.
I read the resolution?
I didn't have a resolution in my
No,
package.
I don't either.
Wait a second.
We have just the lease.
Yeah. No? We read the resolution?
I do.
Or we giving you permission to sign the lease?
Well,
Yes.
yeah, because I don't have a resolution.
Do you have it on your computer by chance?
I don't have my computer here.
Do you want me to go?
What did you just read from?
Well, we don't have anything to read from.
No, we just have the lease.
We just have the lease.
We could just give.
We don't
it-
have a resolution.
That was part of the package of resolutions that I sent out.
He did send it. I don't know.
Well,
why.
let me look.
Performance?
I don't know.
Just give me
No.
1 second.
Can we, want to take a minute, recess and go see if I got it?
No, I
So
can,
aren't we
I
just
can read-
voting to?
well, let me, I'm going to just
Based
go
on the
into my,
emails.
I'm going to go into my minutes.
Wait,
Into
we didn't
my-
get the resolution till yesterday.
I can see this on the
The
website.
actual resolution.
I forwarded it to all the town board members.
Yesterday.
Just give us a minute.
2 days ago.
I put it together, take full responsibility. I loaned my secretary to the highway department for a week.
And look what happens to
Hey.
you. You fall apart.
It would happen if she was here too, maybe worse now. Hey, you know, jeez, women make mistakes, guys do too.
Okay. So was it, let's see, agenda, ZBA meeting?
Emails
I did.
for resolutions.
I'll look in emails for resolutions.
Or should be attached to the agenda if you're on the.
Let's take a
No, you
recess
might
for
not
1
have put
minute
it
and you
in
can
there.
shut the camera so we don't waste time. All in favor of
You have to look at
quick recess? Aye.
recess.
Make a motion to come out of recess?
I'll
Second.
All in favor?
Aye.
I want to thank a member of the audience who pulled it up on his iPhone like that. Okay, now therefore be resolved that the
That's a droid.
supervisor is hereby authorized to execute a lease agreement with the Town of Southeast Cultural Arts Coalition, Inc., for a term to expire December 31, 2016, for space located,
2026.
you got,
A term to expire 2026.
2026.
hey,
Fix it, we'll fix it.
what does that say? I mean, my,
Well, it should be 2026.
I know, I'm only reading what it says. Okay. Sorry. It's 2026, but this says something different. So, ooh,
You lose it?
it was in sleep mode for too
No,
long.
it's locked now.
Come on back up here.
You're on TV, wave to the
Thank you,
camera.
Mr. Cypress. You'll never come to another meeting. Okay.
Thank you.
Okay.
Where's
December
the camera?
Stay up
31,
here.
2026, for a space located at 67 Main Street under terms and conditions contained in a lease agreement as prepared and approved by the town attorney. So moved.
I'll
Second.
second.
Discussion. All in favor?
Aye.
Thank you all. Thank you. Okay. Next we have is a motion for, approve the 2016 chemical bid for special districts. To make it easy, it's going to be on the internet, highlighted in yellow. There's quite a few of them. I'll read off the numbers, okay? Do I need to say what? I'm not even, it's,
It's a lot to say.
yeah. I'm just going to move it as it's going to be posted on the web, and we all have in front of us, so moved.
I second it.
Discussion. All in favor?
Aye.
Go ahead,
I just wanted to say that it's all the low bids.
without a doubt.
Right, were taken, and
Every
we do
one-
this every
Now, the
year.
only exception is under Lime. Two companies bid O.1640, two companies. And we actually awarded to both companies, because sometimes when you call one company, they may not have the product, then we can go to the other company
Right.
as well. So that's the only one that has a duplicate. All the rest are the lowest bid, and those two were the lowest bid
Right,
of the three that were obtained.
so,
And we've already done the motion and approved, so we'll
Yep.
move on to the next one. Next is proclamation for April of 2016 as Teen Driver Safety Awareness Month. Mr. Cohen had come back to the town about a month ago. It was discussed, I guess, at the Traffic Safety Board for this resolution. I got a letter from Sheriff Smith, I think, 2 days ago, and we already had it on the agenda. So this is, again, a public awareness, which we'll read. Proclamation, April 16, 2016, is Teen Driver Safety Awareness Month. Whereas statistics and experience demonstrate that the greatest danger to our youth in the town of Southeast and throughout our county are the dangers posed from traffic crashes, and whereas highway crash statistics inform us that although teen drivers make up only 7% of the driving population, they comprise 18% of the injury-related automobile crashes. And whereas the leading cause of accidental deaths to our youthful population throughout the United States are automobile accidents. And whereas analysis shows that the reasons for teen overrepresentation in injury-related automobile crashes include driver inexperience, excessive speed, unnecessary risk-taking, inattentive driving, and use of alcohol and drugs. Whereas in the town of Southeast and throughout the county, we have too often experienced a tragedy with the death of a teen driver at the wheel. Many of these deaths have occurred during the spring and summer months, with a high incidence rate during their period leading up to prom season. And whereas all accidents are preventable and crash rates can be lowered through the use of education and awareness programs, through the use of our school systems, law enforcement programs, and youth service organizations such as the Boy Scouts, Girl Scouts, Junior RTC, it should be ROTC, I believe, programs, and the Civil Air Patrol, just to name a few. And whereas these programs work best when there is a period set aside for local government at every level, our school districts and churches, synagogues, and youth service organizations come together to provide these educational programs. Now therefore be resolved that the Town of Southeast Town Board do hereby proclaim April 2016 as Teen Driver Safety Awareness Month in the Town of Southeast. We encourage all levels of government, our school districts, law enforcement, our churches and synagogues, our youth service organizations, and all citizens of the town of Southeast and throughout Putnam County to support programs that promote teen driving safety awareness, thereby protecting one of our most precious resources, our children and our grandchildren. So moved.
Second.
All in favor?
Aye.
Supervisor's monthly report. It's still early in the season. We're doing what we proposed, except for our highway budget. And because of the lack of snow, and I'm knocking on wood because we can still have a little, the snow season this year was almost non-existent, which was good. So we're going to be doing a little well in that category this year. But with the 2% cap, which this year I think is as low as,
.073?
no, it's 0.012.
Yeah.
It's like less than a quarter of a percent, about eighth of a percent. So it's really, really bad. The schools are the first ones to feel it. So it's going to be a little bit difficult this year, but it's going to help our highway budget, not the rest of our budget. So right now, we're doing good, but it's early in the season. And again, we have, usually every year, the past few years, we've had good budgets and have stayed within it. You know, we have a couple things pop up. We have a slight contingency to meet those. And anytime I can save money, we save it. Okay, recognition of the public.
John Lord, I'm sorry I got into that public hearing part or
It's
made
my
that
fault.
part of
I
the
let you do it.
He invited it.
Yeah.
But in
I
setting,
learned my lesson. I'll never do it
Yeah,
again.
His fault. His fault.
It's all-
when you set the rates, you have a consultant assist you, right?
We had a consultant, yes.
Okay. And the rate setting, it's a public service sort of thing. It's governed, or the consultant will come up with a formula that has to meet certain standards by the state. Right.
I wouldn't say, not necessarily.
Well, I think as it was stated the last time we went through this process, with a allegedly independent rate consultant, that this is not rocket science.
Right.
Some would say it is rocket science.
Yeah.
Because it is very complicated, and there's a lot of complicated financial factors that go into setting rates. Different consultants have different opinions as to what's fair and what's not fair. So it's to say that there's a hard and fast rule on anything would be incorrect.
Okay. But the purpose is to allow the entity to make a reasonable return on their investment and the services that they're providing.
It's really a two-step process. They have to, the entity that is providing the service has to be allowed a fair rate of return on its investment. And the people that are providing the revenues for that have to be treated in a fair and equitable manner. There are terms of art in the rate-making statute, and in this case, it's the Transportation Corporation Law that says that sort of gives a very broad guideline of what the rate-making board, in this case the town board, has to comply with.
So your consultant should be looking to the Independent Sewer Works to provide as much information on their costs and
When we went through the last process,
Yeah.
they did. And when our independent sewer consultant or rate consultant made a determination or gave us his recommendations, no one objected to
Or challenged any of
challenged the actual revenue. They just challenged what was which was the structure of the rate charged to the individual users.
Okay, cool. If a determination is made by the town that they would go to a usage as opposed to the existing one, probably should make sure that Home Depot doesn't have an opportunity to claw back anything that they paid in
No,
the past.
that won't happen.
Okay.
But I can almost guarantee it will be back in court.
Yeah.
Thanks a lot.
Thank you.
Thanks, John.
Anyone else from the public? Town board members?
Just want to wish everyone a happy holiday weekend.
That's what I was gonna say.
Whatever it is that you observe, and enjoy this. Let's look forward to having as nice of a snowless spring as much as we had the snowless winter.
Okay, Lynn, I know you're gonna touch on
Yes.
trash.
Also, well, I first want to wish Bob a very happy birthday. I know there's nowhere he'd rather be tonight than with all
Happy
of us.
birthday to
57.
Talking about sewage was the highlight of my night.
I knew it would be. Yes, happy
No.
birthday.
But thank you, I appreciate it.
Anyhow, I would like to talk about cleanup day. I'd first like to thank the Village of Brewster, and Christine Puccini is here tonight, because we are going to coordinate this year, which is terrific. They're going to, and Christine, correct me if I'm wrong, but they will be doing their cleanup day on Sunday, April 17th. The town will be doing the whole weekend of the 16th and 17th, and we do need help from the press for getting this message out. So, also Milltown Road has been extremely cooperative. They always are. They are fabulous at picking up their neighborhood, and they're going to do it the same weekend, which helps our highway department. And also the school is involved again, Henry Wells and Irina Othmer with an art contest. So the cleanup weekend is Saturday and Sunday, April 16th and 17th. I will be at Main Street on both days from 8 till 12 in front of 67 Main Street. I'd also like to thank Brewster Shell because they are donating some vests because some of our really busy roads are a total disaster, and some gloves. But and also the public will be able to pick up bags ahead of time at the highway department.
Which is now going to have the money to give lots and lots of bags.
And I want to thank Michael Bruin because he's been extremely helpful now with this. He's going to, we really want to concentrate on that weekend because things are going to leaf out early this year. It's much harder to pick up trash. When it does, it's harder to see it. And I've never seen the town in such rough shape. So thank you to Michael. And please, everyone, help out as much as you can. We really need it, and we want to keep this as an ongoing. But you know what? If people just wouldn't throw trash out of their car, I wouldn't have to we wouldn't have to do this. And so, it's just gotten worse and worse. So I'm asking for everyone's cooperation, and we really need your help that weekend. So that's it for me.
I have to admit, I do get calls. I got one today, and people always imply that we as a town are not doing anything about the trash. I mean, other than following cars as they're going through town, throwing out the window and picking it up, you can't stay ahead of it. We could have a crew, you could have probably a crew of probably 3 guys, 3 gals, or 5. I swear to God, you could send them out every day, and we would still get complaints. If you see someone tossing trash, if you get a plate number, turn it in. But this is not a high priority with law enforcement, okay? Now, we've caught a few people. We got a few people coming into court soon because when they dumped some items, we knew who the person was, and they'll be coming to court. Hopefully the courts will help us out and collect some kind of a fine. I can tell you here at Town Hall, I'm going to the expense of now buying a license plate reader. I'm going to be getting one for the highway department as well, because people are terrible. And I'm telling you now, it's not the residents of town of Southeast always, not just residents of Patterson, Connecticut. And almost every municipality in Putnam County and Connecticut as well, they have places where people could dump trash, but they don't want to bring it there. I don't know why they want to go along a road and dump it. I talked to Michael Bruin earlier this evening, along with some of the members of the board. He's out almost all the time. If we get a phone call, we go pick up the trash. And, maybe in the old days, it was on a county road, you'd call the county, state road, you call the state. We don't do that. If we get notice that there's trash out on the road, now big stuff, I'm not going to go out and pick out, a piece of a coffee cup or a napkin or paper plates. No, we can't do that. But if we find someone who dropped a large piece of equipment, such as an Xbox that was dropped here one day, didn't work, so I couldn't use it. They have washing machines, dryers, refrigerators, tires. We here in the town of Southeast have bulk pickup once a year? Once a year.
Well,
Twice.
once
Well,
and then one on
Once a
call.
year,
Once on
and you get
demand.
one call. There's absolutely no need for someone in the town to drop it off. So I get offended when they tell us we don't do anything, because we do. We do it often, but there's no way for us to track all these people down. So if you see something, say something. But again, it's not what the saying is, what they're looking for, terrorists and things of that nature. But I'm telling you right, they're terrorizing our community, not just the town of Southeast, all over. And, please, we do our part. We need you to help us do that as well. And I think we're going to be looking to do maybe a second pickup. Simpson Road, we've gotten a lot of complaints about. It's between town of Carmel and the town of Southeast, a lot of complaints. But that is a very dangerous road. Someone was killed there years back, setting up political signs. And that is one of the tougher roads to clean. We will be out there doing it. We have to have additional protection. We might even ask maybe one of the sheriff's departments to maybe go behind the vehicle as it's being picked up on that road. Milltown Road is not a charm to pick up either, because even though it's posted 30 miles an hour, they're not doing 30 miles an hour. So we do our part. And when people call me, and it's one time, I won't say I pick a fight, but I do speak to them and tell them, we're doing our part. And I thank the board members for what they do. Lynn, I know you take this as your yearly Easter egg hunt, go out there and get trash. So we thank you for that.
Just, I know if you do see your car throwing litter out the window, if you get the plate number and you call the sheriff's department non-emergency number, they will send a letter to the registered owner. Not that they can do anything about it because the officer didn't witness it, but they will just tell them that it was reported to them and please not to do that again. So hopefully people will get the lesson with that. But there is a lot of illegal dumping I see going on. I know Pugsley Road and contractors, toilets, everything is dumped on the sides of the road. So it is a big problem. And if you definitely see any of that activity going on, please report it.
Right, because if it's an out-of-town I see that and perceive that as a problem. If out-of-towners who do this. So
The thing is, we don't know who does it. We do find a few. We've gotten a couple. But it's $1,000 fine for fining. We haven't gotten a $1,000 fine yet, because my 2 cameras cost me $1,000, so someone's paying for it soon. Anyone else? Happy Easter to all, and is there a motion?
I'll make a motion, we close tonight's meeting.
I'll second.
All in favor?
Aye.
Thank you all for coming.